Hi everyone, my name is Armine Bazikyan from Bazikyan Law Group, and this month I want to address a concern that parents bring up frequently in my office, and that is, how do I make sure that when I leave my hard-earned assets to my children, that they are protected from the spouses? So the parents are concerned about their son-in-law or their daughter-in-law taking the asset after their death, or putting the asset at risk following their death. So for example, let's say David and Martha are concerned that their son Sam, when he receives his inheritance, that Sam's wife is at some point going to take it during a divorce, or following Sam's death, they don't wish for those hard-earned assets to trickle down to Sam's wife. What they would prefer is for it to go down to the children instead. So this is the main concern that parents are worried about. And we can address this in a number of ways, but I want to go through a few illustrations really just to show you what it is that we're working with. So if the parents have no estate planning done whatsoever, we're going to be leaning on the probate code. So we're going to be leaning on the laws to tell us what happened. So let's say David and Martha don't do any planning. David dies, then Martha dies. They have one son, Sam. So Sam receives all of the assets through a process called probate, which is a court process. We've talked about this probate process in previous videos, and we'll have a link to the videos in our newsletter if you want to learn more about that. But basically, it's a court proceeding. At the end, the judge gives everything to Sam, and Sam is now the rightful owner of whatever it is that David and Martha own. Let's say it's a house and some cash. The concern is that it's now Sam's, which means that after he receives it, if he turns around the next day and he actually transfers it into a joint bank account, so let's say it was $1 million cash, just to keep it really simple. If he turns around and he deposits that money into his joint account with his wife, now all of a sudden she's co-owners with him. She's a joint owner, which means that if a year later his wife divorces him, she has a claim to a portion of that money as being hers. We live in California, which is a community property state, and that means that half of everything owned jointly is going to be considered belonging to one spouse and the other half belongs to the other spouse. We do have a small little really good rule that says that an inheritance from a parent or any other family member, basically anything that you receive as an inheritance is considered separate property. So that's a really good rule that will help Sam in this scenario. But what he has done is received his inheritance. At the point that he got that $1 million, it was actually considered his separate property. But the minute that he put it into that joint account, we're going to consider that to be a gift to the community, to the marriage, to his wife, which means that his wife is going to walk away with half if he has a really good divorce, if she has a really good divorce attorney. But let's say that she doesn't divorce him. Let's say a year later Sam passes away, and Sam hasn't done any estate planning whatsoever either. And what ends up happening is whatever's in Sam's name, he did the right thing. He kept everything just in his name. It goes through a probate proceeding. And during that probate proceeding, the judge, because he didn't do any planning himself, is going to give a portion of that to his wife and a portion of that to his kids if he has any. Let's say he does. So his wife actually walks away with a portion of the inheritance. So if we go back to the original parents, that was not their intent. Their intent was for Sam to get it, and after Sam, for it to stay within their bloodline and go to their grandchildren. So if Sam's wife remarries at some point, all of a sudden these hard-earned cash that the parents have worked so hard for is going to end up being used by people that the parents didn't really intend. So this is the result if you do no planning whatsoever. If you want to take some of that control back and really make sure that what you've worked hard for ends up being used by the right people in the future with the right hands, you have to do some planning. And within that estate planning world, we can control everything and anything that you want. We can control who gets it, how they get it, how long they get it. So the beauty is that we can make it as complex as possible, or we can make it as simple as possible. So let's say the parents don't want to do anything very restrictive or complex for Sam. They're just concerned that it goes to Sam, and they say, you know, when Sam is gone, if Sam's not around at our death, we really want to make sure the grandchildren get it. We can make that happen in a very simple or structured estate plan where it goes to Sam. If Sam's not alive, it goes to his kids. It in no way, shape, or form ends up with his wife. So there's no danger there. We can also make it very complex. We can do a lifetime trust for Sam or a dynasty trust. So the more complex planning we do, we actually have more money to deal with, which justifies the actual cost of setting up these complex vehicles. But we could create a very complex trust for Sam. Within that trust, we can say, Sam, this trust is yours. Everything stays in this little basket trust that we've created. Think of it like a basket. And when you're alive, you're going to use up whatever you want. And when you're gone, you don't tell us where this goes because your parents have chosen already, and it actually goes to your kids, and then it goes to your grandkids, and it trickles down the family tree. So at no point does Sam have control to a point where he wants it to go. So he can't say, okay, now that my parents are gone, I want my wife to be involved and I want her to get half. So we could actually make it very restrictive if needed. It just depends on the type of assets that we're dealing with. Most of the time, people want to lean towards the more simple structure because they want to give more flexibility to that beneficiary, to Sam, to be able to do with it what they want. The important thing to note here is that in California, an inheritance is considered a separate asset. So if Sam is aware of these laws and he receives it, it's his. Now, if he turns around, and this is what I tell my clients all the time, if he turns around and he shares it with his wife, there really isn't anything you can do other than that complex structure. So it's very important, at the very least, that you do some sort of planning, because as we saw in that previous example, no planning at all ends up definitely risking your assets. But at least if you could do some sort of planning, you're controlling some variation of what happens depending on you. So again, you can do very simple planning, you can do very restrictive and very complex planning, whatever it is that you prefer. It is your assets and you've acquired them, I'm sure, through sweat and tears. So most people want to make sure that it ends up in the right hands at the right time. So contact our office. We absolutely provide free consultations. We'll sit down with you. We'll look at the type of assets that we're dealing with, and we'll kind of give you some advice on whether it's appropriate to do a more complex structure, what it is particular in your scenario that might be working out well for you. So give us a call and schedule your free consultation today.